So let's move on to a partnership. First, a general partnership. Well, you can't have a partnership with yourself, right? You can't have a sole proprietorship. You can only have a sole proprietorship if you have one person. You add another person, by default, you've at least become some sort of a partnership, right? So what is a partnership? It is a voluntary association. Just like a contract is a voluntary agreement, right? No one forces somebody to do a business partnership, right? It's something that you do purposely with one another, right? So it's a voluntary association of what? 2 or more persons. 2 or more. Could be 30 partners. That wouldn't be a very 30-person partnership would not make sense from an administrative standpoint, but anything is possible. But it's a group of people, as little as 2 people, that are carrying on a business. You don't start a partnership for a not-for-profit. That's different. It is a for-profit business. That doesn't mean you have to make a profit. It just means that the intention is to carry something out as a for-profit business as co-owners. And the word co-owners sort of surprises people because co-ownership sometimes implies equal ownership. Doesn't have to be. A general partner could invest much more into a business than their fellow general partner, and as a result may wish to take out more in profits or more in losses as a result, right? So co-owners essentially means that you are joint owners, but it doesn't necessarily mean that everyone has an equal stake in the ownership. But now you've got a legal entity, and that legal entity creates rights and duties among the partners and also, very importantly, with third parties. Because you're conducting business together. People are coming into your place of business. You are entering into contracts with third parties. What are the rights and obligations? Partners are personally liable for debts and obligations. In fact, I think you should write general partners are, because here really we're talking about everyone being a general partner. So if one of the things that we wanted to achieve by setting up a general partnership was because we wanted to have we didn't want to have personal liability, we haven't accomplished that. In a general partnership, you are still responsible as a partner. Now, it's true other people are in it with you, but you're still personally liable for debts and obligations of the business, okay? And as we said, state law governs how you set up each of these business entity types. There is something called the UPA, the Uniform Partnership Act, that establishes consistent partnership law. Remember the UCC? I know you want to forget about it, but you recall what the Uniform Commercial Code is. It is model law that most states have adopted. Why? Because we want uniformity and consistency. Well, similarly, a lot of states have adopted a very similar version of the Uniform Partnership Act. So there are not that many differences between New Jersey and California and Delaware and name another state, whatever. It's very similar in terms of how you set up a partnership, what kind of filings you have to make, what the laws are with respect to profits and losses in terms of how you allocate them and so on. It's pretty similar. And we'll see that that's true not just of partnerships but of LLCs and model law, meaning most states have adopted a similar version of the same thing. Again, not as formal. Yeah, there are filings required, but here we're still talking not as much quote-unquote paperwork as, say, a corporation would take or a limited partnership might take. Now you're running a business with more than one individual. There's 2 people or there's more than 2 people. What's the name of your business, right? And here, again, you can, you have a choice. You can pick any name. And I don't want to say any name in the sense that it's totally up for grabs. It can't be an obscene name. It can't be a name that infringes someone else's trademark or intellectual property. Barring aside that, you could make up a name. That's what a fictitious name is. Or you could use your last names, whatever the case might be. Some states require, and it's becoming more and more archaic, is that if you're going to operate your business as a fictitious, meaning a made-up name. Not only do you have to file a doing business as statement or filing with your state, but you might have to take out an ad in a local paper. Give notice that, you know, John Smith and Susan Smith and Derek Jeter, I don't know where I come up with that today, I don't even like baseball, are running their business as eeny, meeny, miny, mo, whatever. I mean, you have to give notice who, you know, that used to be when people actually read newspapers. Today, you know, it's sort of like, does newspaper notices even make sense? But, you know, state law may require it to some degree. But still, we're not talking about a whole lot of formality. We're not talking about a lot of money to pay to set up a business as a partnership. Partnership agreement is essentially a contract between the partners. Is it required? Does state law require a business to have a general partnership agreement? Let's just get that out of the way. Exactly, not required, but it is absolutely a good idea. And we'll see why in a few minutes. So you could have a written agreement signed by the partners. It doesn't have to be filed. It is your governing document. For example, think about a corporation. A corporation adopts a set of bylaws, right? The bylaws tell you, well, how many directors do you need? How much? What's a quorum? You know, what kind of shares are we going to issue? Blah, 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 right? It's a sophisticated form of business. You need to have that detail. You know, I mean, a partnership is sometimes a very simple thing. It's two people. It's two friends starting up a business, and we don't need an agreement. That's silly. For sure, it's not required under state law. We're not. Now, do I need to tell you that business and friendships do not always mix very well together, right? Wherever money becomes, you know, I mean, that's, so, you know, when things are good, write down your expectations. Say, how much are you investing? How much am I investing? How much profits and losses are we, how much work? Are you going to do the work in return for putting in less money? What are these rules? Otherwise, you're going to have a default partnership law that is going to define it. And that may not be a good idea. So no formalities are required for a partnership agreement, meaning no filings, no particular form, but it is a good idea to have. What is the taxation of general partnerships? Just like a sole proprietorship, except that you have more than one owner. There are no federal income taxes filed at the partnership level. You may have to file an information return, a general information return that something is a partnership and it has so much in incomes and losses, but you're not paying taxes at the entity level. Again, income and losses are being reported on the individual partner's personal income tax return, and that is what we refer to as flow-through taxation. So you get the tax benefit, but you still haven't gotten the limited liability benefit in a general partnership. What are the rights and responsibilities of general partners? Well, the rights are each partner has a right to participate in managing the business. They have a right to share in profits. They have a right to compensation. They have a right to indemnification or reimbursement. What does indemnification mean? What does reimbursement mean? It means if you as a partner spend money on for business purposes, you have the right to get reimbursed or get indemnified for that. Right to return of loans, meaning if you lent money to the business and the business dissolves, you have the right to get that money back. The right to your capital contribution to the extent that there's still liquidity in the business when you dissolve, and a right to get information. Even if you might be, quote unquote, a silent partner, you are still a general partner that has a right to know the finances and the books of the business, right? Those are rights that you're entitled to as a general partner, whether or not there is a partnership agreement or not. Yes? The rights are given under the state law, under the Uniform Partnership Act. Yes? You can vary some of these rights. For example, you may have a very eccentric, I use the word eccentric, not cuckoo, but an eccentric partner who cannot be trusted with business judgment but has deep pockets, right? You say that that individual does not have management rights. They have a right to invest, they have a right to profits, but we do not want this person running the business. You can limit their right to management. But not saying that means default rules. And by the way, another quick point, and I don't know if it's necessarily in the slides, right to share in the profits. And this is an important point with general partnerships. Let's just make it simple. Two people are investing in a business together. Person A is going to put in 75% of the capital. I'm just making it easy. You need $100,000 to invest in the business. Person A is investing $75,000. Person B is investing $25,000. They're both working together. They're doing 50-50. Business is ridiculously successful. And in their first year, they make $50,000 in profit. Oh, let me make it easy. $100,000 in profits. $10,000 in profits. How can you invest $100,000 and get $10,000 in profits? How should profits be divvied up? And they have no partnership agreement. What does state law say? State law says 50-50. If that wasn't your understanding, if you wanted it to be based on the percentage that you put in, what should you have done? Have a partnership agreement. Do you understand where the fight's going to come from two people that actually got along? You know, maybe they even had an oral agreement. Maybe they sort of, one person said, but you know, we'll take based on, but you didn't write anything down. State law mandates 50-50 unless the partners have other understanding, and the partner that contributed 25%, what do you mean I only get 25? I'm entitled to equal share under state law. So if you want to vary that in a general partnership, you have to say, you know, there may be a partner that wants to take more of the losses. You know, initially, let's face it, a business is not very profitable. And it may be that a high worth individual would rather absorb higher losses because they can take it to set off income. You got to say it. Otherwise, it's proportional to your capital investment, right? So that's why it's so important to have first an understanding of what the state law has its requirement, and if you want to vary it, that you need to have an agreement, a contract among the partners. So there are rights, and then there are obligations or duties. Duties of general partner. This is sometimes why people want to rather be in business with themselves. Now you have a duty of loyalty to your other partner. You have a duty of obedience. You have a duty of care. You have a duty to inform every other general partner. Yes, you have access to more capital, but you have all of this that comes along with it. What does all of this mean? What is the duty of loyalty? Now we start to get redundant, because remember we just talked in agency law about what the duty of loyalty means. It's a fiduciary duty. It means, for example, that an agent can only act in the interest of the principal. Well, same thing, a partner should act in the interest of the partnership, not do something that is adverse or against the interest of the partnership. For example, self-dealing, taking a partnership opportunity, competing with the partnership, making secret profits, taking a breach of confidentiality, using partnership info for your own gain, misusing partnership property. I mean, that's not to say that a general partner can never invest in a competing business. But if they never tell the partnership, if they don't disclose it, they have technically breached a duty of loyalty, right? Because how can you be loyal to this business and also try to get business by having a side business on your, you know? Now, again, it's not that people don't do it, but they have to disclose it. Because knowing that could mean that you don't want to go into business with that person because they're going to, try to make money here and try to make money on the side. Well, we don't, we want someone who's totally invested in this business, right? So all of these things come along with partners owe to each other fiduciary duty of loyalty. General partners, and we're only really talking about general partnership here. Duty of care. What is the duty of care? The duty of care is a reasonable duty to act at the same level of care that a reasonable person would do. So if you as a general partner are running the day-to-day business, you have a duty to act reasonably, to act with sound mind, sound business person. It's not to say that every decision you make is going to be the right decision, or it's going to have the benefit of hindsight, but you're supposed to act with reasonable intentions and not ill intentions toward the business. Doing so would mean that you could breach a duty of negligence for which the partnership and the other partners could sue you for negligence. Duty to inform. Inform whom? Inform each other. It might be that I've invested 75% in the business because I don't want to have the day-to-day responsibility of running the business. The person that's invested less is actually running the business. Well, to the extent that we get an environmental citation or we get a tax audit or something like that, you have to make sure that you tell your other partners about it so you make management and business decisions in a sound way. Right? Because the law says that other partners are imputed with knowledge of all notice, meaning even though the notice was sent to the partnership address, every partner is assumed to know what's going on in the business, whether they're a silent general partner or an active general partner. Right? So you start to see that there are rights, duties. It's not just filing a partnership papers with the state. There's a lot more involved when you've got other people running a business with you. Duty of obedience. What does that mean? Well, it means to the extent that there is a partnership agreement that you abide by that agreement, right? And it means that if someone is said to not participate in active management, that they keep that role. Otherwise, they violated it. Now, what do you do if one partner misbehaves, or doesn't listen, or violates, or steals, or violates a duty of loyalty, or whatever the case might be? You can't technically sue the partnership, okay? But what you can do under state law is go to court and demand an action for accounting. And what that basically means is having a formal process, a court process. You want to try to avoid that, right? You want to obviously, before you go to this step, go to the courts, want to reach some sort of compromise, want to negotiate, want to try to buy out the partner, do what you can. But barring all that, can't reach, you can go to the court. And this is, again, a judicial process where the court will review whatever transaction or whatever is at issue. And it could be that the business gets dissolved as a result of it if it is impossible for parties to either reach agreement or compromise, or it is not possible to run for example, what if it's a two-partner partnership and one partner is absolutely off the handle or is embezzled or done something? Partnership by its very nature will have to be dissolved, right? So the takeaway here is that yes, general partners owe to each other a duty of obedience, a duty of loyalty, and to the extent that things cannot be resolved, it may be possible to go to court to resolve some of these disputes, and that action is referred to as an action for an accounting. Everyone with me? All right. Liability. We haven't solved the problem of unlimited liability. Why? Because if we've got, for example, 3 general partners that have, for example, put in equal amounts, 33, 33, 33, and the third capital contribution, capital investment into a general partnership, the problem here is that if they owe more money to a third party, not only is the third party able to go after the business, they're able to individually go after the general partners. So you still haven't solved that problem of unlimited liability. You have people with whom you share that burden, unlike a sole proprietorship where it's just you, but the problem is, your house, your cars, your yachts are still on the chopping block because third parties are allowed to move against those. And what could that liability be? Where could it come from? Well, it could be tort. Remember what a tort is, right? It's negligence. It's any kind, what if you infringed, what if it's product infringement, whatever. Or it could be, as we'll see, contract liability, where you have a contract with a third party that you breached. For tort liability to third parties, again, it's unlimited personal liability for each of the general partners. And, again, there's a lot of terminology here. Joint liability, joint and several liability. I want to explain it. I'm not going to get this technical. This is not a law school course. But what joint and several liability means is that a plaintiff, for example, let's just say the general partnership is is an accounting partnership. You're doing, one of the accountants breached, committed negligence. Okay. It's up to the plaintiff whether they sue just that partner or whether they sue all three partners, even though the other two partners had nothing to do with that matter, or they sue the partnership in the partnership's name. Joint and several liability means that plaintiff can sue anybody within that partnership, and plaintiff can recover everything from everyone, meaning you're really giving, in a general partnership, you haven't really protected. You can't just say, well, one of my partners is sort of weak, and if they sued for they're sued for negligence, I don't have to worry because I'm never going to get sued. Sure you are. You're a general partner in a general partnership. You have joint and several liability, meaning that a plaintiff will more than likely sue all of you. And to the extent that your other two partners don't have the resources, personal resources to pay out, and you're the only one that you do, you're liable for negligence that you didn't even commit yourself, but was you could be liable for all of it. You could be, because you could be the only one named. And you might say, well, why would they do that? Right. They could. They could. Yeah, if they're the only ones with the deep pockets, they could. Now, as we'll see in a minute, there is a right to indemnification. You could turn around and sue the other partner, but the problem is vis-a-vis third parties don't have to care. Partnership committed negligence. I don't care if it's partner A or it's partner B or partner C. Partner C never was on vacation, never even reviewed the return. Doesn't matter. That's a downside of now you might say you have malpractice insurance, you have all of these other things that you're not personally, but again, you can never fully understand how big liability could be. So yeah, it is, and we'll get to, well, what about indemnification from yes, it's still possible, but let me just tell you, in the real world, plaintiffs are going to always go after the deeper pockets. That's just the reality. They want to get reimbursed, right? And that's again understanding the downside of being a general partner in a general partnership. What about contract liability? What if the partnership in the partnership's name signed a contract that they breach? What if it's for, lease of a building and they break that lease and they're responsible for the payments for the next however many years that the lease is going to run? Again, unlimited personal liability. Here, and this is not a difference that I think you have to, memorize. The thing with contract law is if a party is suing, a third party is suing for a breach of contract, they cannot just sue one of the partners. They have to sue all of the partners. They have to name them all as defendants. But to the extent, again, two of the three partners are bankrupt and only you're the last person standing, you're still liable. Again, that's the problem with unlimited liability in a general partnership. And I think there's a nice sort of a summary that we'll go over in just a minute. But real quickly, partnerships over time have people that leave, new people that come in as general partners. What about liability of outgoing and incoming partners? Well, here the rules are pretty much common sense. Liability of incoming partner, liable for debts and obligations only to the extent of capital contribution. So if someone comes in as a new general partner, okay, and let's say, it's a business where it's a $100,000 contribution, I'm making a $25,000 contribution, but I only came on today, on March 28th, 2015. If something happens where there was a contract liability that existed before I even came in, and we're sued, I could lose my capital contribution. Sure, I can lose any money that I put into the business. But the problem, the question here is that if there is contract or tort liability that was existing before I came in, a negligence that was done on January 1st, 2015, I am not personally liable for that. I only incur personal liability going forward as an incoming partner. Does everyone understand that? Or should I say that again? Incoming liability, yes, I can lose my capital contribution, but my personal liability is from that day forward. Now the reverse of it, liability of an outgoing partner. What if I leave today on March 28th, having committed all sorts of sins in the past, right? And what if the partnership is sued based on my negligence on January 1st, 2015? Liable for debts and obligations incurred at the time that I dissolve or I leave the business. I'm still responsible for that. Not liable for anything that happens going forward with respect to personal liability. So this is common sense. But again, we're talking about a business that outlives each of their individual general partner owners. I think this is the slide that I was talking about. It's a very helpful slide in helping to understand liability of general partners. For example, what's the issue? Type of lawsuit, contract or tort? And the rules are pretty much the same. The defendant, under joint liability, plaintiff has to name everyone as a defendant. Under joint and several liability in a tort action, plaintiff can choose to name one partner and not name the other partner. That's detail you don't have to worry about, joint and several liability. But the understanding here is that everyone is liable. So what's the recovery? If successful, same rule. The plaintiff can recover the judgment against all or any of the defendants. It just matters where the deep pockets are. But here's the thing. What if I paid out as a general partner, but I wasn't responsible for the breach? I wasn't responsible for the tort. Yes, there is indemnification. Partner who pays the judgment can recover contribution for other partners for their share of the judgment. The problem is if the other two are bankrupt, what can you do? So you're always taking that risk in a general partnership. You are to third parties responsible. You may have a right to indemnification later on, but you're responsible. So you haven't solved the problem of unlimited personal liability. And with each of these types of businesses that we'll talk about, well, how do you dissolve the business, right? I mean, business can run into perpetuity, or a business can be terminated, right? It's a voluntary association of people which can voluntarily decide that they don't want to do this anymore. So technically speaking, any change in the relation of partners will cause that business to be dissolved. So for example, if a partnership has 4 partners and everyone has invested 25% and there are 4 people, and you file your notice with the state with those 4 people, and you are cashing out one of those people. You choose to. And now you're going to be left with 3 partners. Technically, the general partnership has been dissolved. Now, what if you decide that you want to continue with those 3 people? You can. Technically, you have to terminate the old partnership, and now you have to file papers again to be in. You can keep the same name if you want to, and so on. Why? Because the structure has changed. You went from 4 to 3. Or what if you stayed at 4, but you're letting go one person and you're taking on another person? You still have had a technical change in relationship for which there is formality and filings that are required. Okay. Not every change results in the business dissolving, but sometimes it does. For example, if there were only 2 partners and one wants out and there's just no way that you can convince them to stay, it's over, right? There, the business has to be wound up and dissolved. So what do? Well, you liquidate the partnership assets, and sometimes there isn't much to do. You were renting space, you're not renting space anymore. You have to pay off your landlord or whatever the case might be. But you're basically resolving your business, and you're winding it down. A wrongful dissolution. A partner withdraws from a partnership prior to the expiration of a term. It may be that you signed an agreement, that in your partnership agreement you said that certain person cannot take away their capital contribution, cannot ask to be leaving the business more, before 5 years or 10 years or whatever the case might be. In that case, you breached the agreement. So it's possible that a partner leaving early could subject them to a lawsuit. You can't force somebody to stay, but their departure could lead to a wrongful dissolution for which there might be legal repercussions that the other partners can take against that partner. State law might require you to tell third parties our business is dissolving. You may have to give notice. You may have to take out yet another newspaper ad. Again, that's changing. You don't have to do these formal things, but you used to have to do them a few decades ago. You have to give a formal notice of dissolution. And then, again, to the extent that the business is a fairly successful enterprise, it may be that you have to, in order to take money out, right? Everyone, when they dissolve a business, give me my money back. Well, no, it's not. Capital contributions don't come first. First, you've got to pay off your creditors, right? If you just broke a lease, there may be consequences to that. You still have to pay your employees, right? So you got to go through creditors. Then, to the extent that partners lent money to the business, then they get paid. Then, to the extent that there's something left over, you get your capital contribution back. Then, to the extent that there are actual profits on the table, you get to divide them in the way that your agreement said, or equally if that's the arrangement. So again, you start to see that, yes, running a business with other people involves a lot more formality, a lot more legality than obviously having a sole proprietorship. But again, advantages, disadvantages, right? Not everything is suitable for every type of business at every stage of that business. Our job is to just understand how the process works. And again, point that I cannot make enough: if partnership cannot satisfy the claims, creditor claims or otherwise, partners are personally responsible. We're talking about a general partnership here. And as I've already said, it is perfectly conceivable that a partnership could technically dissolve because a partner leaves and another one comes in, but partners can continue. They can file a continuation statement with the state. So it is possible to continue even after a quote-unquote dissolution. Another point that I want to quickly make is something called the right of survivorship. And this is something that exists with partnerships, which I think is a very limiting facet or limiting attribute of a partnership that people need to understand about general partnership. The right of survivorship says the following: if one of the general partners passes away during the time that the partnership is conducting its business, do the heirs of that partner get the capital contribution back right away? What I mean by that is, for example, let's say there are 4 partners, and they've each invested $25,000 in a business, and the business is happily running along. Partner A dies of a heart attack. Partner A, under his will, has said that all my property goes to my beloved wife. The beloved wife is getting X, Y, and Z. Does the beloved wife get $25,000 taken out of the partnership because that's the capital contribution? The answer is no. Why? Because there's right of survivorship. Now, it doesn't mean that okay, let me stop calling it the beloved wife. Let me just say the heirs, it's not like you lost that interest. It just means you cannot force the partnership to cash out that partner. The rights it used to be a 4-partner shop, now it's a 3-partner shop. What happens? The value of that interest passes to the heirs, means the profits and losses now go to the heir, but there will be no cashing out or liquidation until the business dissolves. And you have to understand, what did I invest in? If it's a general partnership, you can't. Now, it may be that in your partnership agreement, you work that in. But the law doesn't say, the law has a right of survivorship in a general partnership. And that is an important attribute to understand, which is the reason why a lot of people change the type of business, because a general partnership might be too limiting for those types of business owners. I mean, you know, sometimes it's just an investment and you want your investment out, and even death may not allow someone to be able to do that, accomplish that legally. And we're going to cruise right into limited partnerships, and it's not going to take us very long, because we'll see with limited partnerships that a lot of the general partnership rules still keep coming along, but we're going to introduce a new set of players, limited partners. And we're going to start to see some protection with limited liability. What is a limited partnership? Or, you know, not a GP, general partnership, but an LP, right? We've seen LPs at the end of names of companies. This is a limited partnership. What is a limited partnership? Well, it just means the type of business where there are two types of partners: general partners and limited partners. We already know who the general partners are, right? General partners are people that owe duties of loyalty and so on, and obedience and all of that. They invest capital, they manage the business, and they are personally liable for the debts and obligations of the partnership debts. But if you want to set up a limited partnership, you can actually have certain individuals, or, you know, sometimes partners are not individuals, sometimes they're LLCs, sometimes they're corporations. There could be any, you know, partner doesn't have to be an individual, it could be an entity, right? You could let in limited partners that invest capital, because God knows we need money to run a business, but they do not participate in the management of the business. And as a reward for not managing day-to-day operations, limited partners are also not personally liable for partnership debts and beyond their capital contribution. So, for example, you know, again, limited partnerships, a lot of appeal before LLCs came in, right? So imagine a world where you can't otherwise limit your liability. So if all you had was sole proprietorships, general partnerships, and all of a sudden limited partnerships came along, terrific. You have the ability as an entrepreneur, a business person, to invest in a business, but to not have personal liability beyond the money that you put into the business. And all you have to do is not participate in the management of that business and be called a limited partner. Okay? That's the difference. A limited partnership has both general and limited partners. So an LP has at least one general partner and at least one limited partner. It could have more than that, but that's the minimum requirement. No restrictions on maximum number of either. Any person can be a general or limited partner, and in fact, it could be a corporation can be a limited partner. It doesn't have to be an individual. I think there's some redundancy there. Now, let's talk about how do you set up a limited partnership. Well, again, there is formality required. You have to file in the state in which you want to become a limited partnership. And again, we're talking about model acts. Remember we said there was a UPA, the Uniform Partnership Act. Well, in the world of limited partnership, there's something called the Limited Partnership Act, or the LPA. And now there's a revised version. I don't get this nitpicky. All I want to have people to understand is that there are model laws. States basically have the same types of rules in terms of what it takes to form a general partnership and what it takes to form a limited partnership. The rest of this is all history. First, there was a Limited Partnership Act. Then you had a Uniform Limited Partnership Act. And then you have the revised whatever. All it does is gives you the basic foundation for limited partnership. And it requires certain things. What it requires is that you make a filing. You file a certificate of limited partnership, which means something that has to be signed by the general and limited partners that gives notice, that is a filing that anyone in the public can look up, that basically shows who are the partners, What kind of partners are they? Are they limited or are they general? Where are they doing their business? What are they contributing to the business? What is their capital contribution? And did they dissolve, meaning did one limited partner come in, another go out? What happens when that composition of the group changes? That certificate is public information, right? So we start to see more formality. And in order for a limited partnership to be a limited partnership, you have to properly go through and accurately make the filing. Now let's talk a little bit about foreign and domestic. And here's where people get confused. Foreign? Other countries? No. No. You are a domestic business, for example, a domestic limited partnership. If here in the state of New Jersey, you file your certificate of limited partnership. I am domestic in New Jersey as a business. But I ship products to New York. I have a satellite office in Connecticut. Well, I've got to do something there. I have to set myself up as a quote-unquote foreign limited partnership. I'm foreign to the state of Connecticut because I'm actually set up in New Jersey. So I have to make a filing in those states. I can't just do business there. I have to, limited partnership in every other state in which it was formed is considered foreign in those states, which means, the law of that state, basically the law of New Jersey will govern our internal affairs, but I still have to make a filing in every other state. It's called a certificate of registration. It's a pretty easy thing. You can do it electronically, but you are required to do that if you're going to conduct businesses in those states. Yes? Correct. And when you say company, right? Yeah. I mean, and we all use the word company. Now we have to sort of, what am I talking about? Am I talking about a corporation? Am I talking about a limited liability company? Am I talking about a partnership? If so, what kind? So yes, but the good news is that the rules are the same. Whether you are a partnership, an LLC, a corporation, you are considered domestic where you set it up. You are considered foreign everywhere else. So I know you're talking about Delaware, you're talking about a corporation. Because a lot of corporations are incorporated in Delaware for various reasons. Yes, all of the financial companies that are incorporated in Delaware are considered domestic in Delaware. But of course, they're doing business in the other 49 states. They have made filings in all other states, but the laws of Delaware apply to their internal corporate structure. And that's true of corporations, but that's also true of other business entities as well. And if I'm here in the state of New Jersey, I can incorporate, or I can set up an LLP or LP or GP. I'm domestic here. I am foreign everywhere else to the extent that I do business across state lines. But the point that I'm making is that there's formality, right? I'm not a sole proprietor anymore. I have to file and register and pay fees and keep my certification and registration current. Names. Just like we've been through names of general partnerships, names of limited partnerships have to be, properly filed and so on. The one little quirk here is that if you're a limited partnership and you've got Donald Trump to come in and become a limited partner, you can't use the Trump name. Why would you want to? But regardless, you can't because you cannot use the last name of a limited partner because it's misleading. Because a limited partner is sort of a partner that is they contributed capital, but they're not managing the business. So yes, you can use whatever name you want to. You can even use names of people, but if you're going to use names of people, it can only be general partners. It cannot be limited partners. Yes, that's okay. That you have to say LP. I missed the first part of your question. Does there have to be? a cap with, in terms of how much?
How much capital have to be in the company?
It depends on the type of business. I mean, it depends. Like, are you saying does state law require? Could a limited partner just put in a nominal amount? Or, not that I'm aware of. That could a limited partner own 90% of the business? But if they own 90% of the business, they're limited liability. There might be. I can't speak off the cuff on that.
I think my question maybe I'm planning to create a company.
Okay.
And I think which one can I create? For example,
Oh.
now we're talking about expenses in terms of filing and everything.
Oh, okay.
But do I have enough
Capital.
to create that type of business?
I see. Now I understand. So the question really is, when I'm choosing the type of business entity that I want to set up, do I have to be structured in a way? Do I even have enough capital contribution to become a limited part? And that's an excellent question because you're going down the road where we're going to sort of wind up. So the short answer is no. You don't worry about general partnerships because they're going to be personally liable. You don't even worry about limited partnerships because there's always going to be some general partners. But in order to form, for example, like an LLP, a limited liability limited partnership, state law may require there to be either minimum capitalization or, more importantly, the trade-off is that you carry enough in insurance. That, because if you're setting up a business where no one has personal liability and you run off all kinds of debts and obligations, where are the deep pockets to pay any of this off from? And the way that state law manages giving away personal liability is that they require the business to be either properly capitalized or for them to carry a minimum level of insurance. So third parties do not get adversely affected. But the short answer with limited partnership is no, there isn't. And we will come back to that concept as we move along. All right, so we've talked about names. Yeah, don't infringe on anyone else's name, but pretty much speaking, you can come up with any type of a fictitious name. Don't use misleading things. Don't call something a company or a corporation if it's a partnership. Don't, don't not use phrases like, don't just say partnership, because that doesn't tell you what it is. An LP or limited partnership tells you what it is, and it tells the world that some business owners will not be personally liable. So a lot of state laws will say, if you're setting up, Jane Smith Enterprises, that you say LP at the end, because that has meaning. It shows that there are business owners within that business that will not be personally liable. And it's up to anyone who lends money or invests in that business or does business with that LP to do their homework to understand the structure of that business or to ask the tough questions if they want to be sure that they are protected adequately if the business defaults on a liability. So yeah, I mean, there's sort of these things that you have to worry about. Capital contributions. Partners can lend anything. Mostly they give money. They can give money, they can give property, they can give their services. Whatever it is, a contribution from a partner can be anything. What if you're starting up a business and you're taking capital contributions? No one has pledged, but you say, well, I'll set up a business if, here's my business plan, here's my proposal. Limited partner A pledges, agrees in writing to give $100,000 in seed money. Limited partner B agrees to give $20,000, and you've sort of, now that you've set up the business, you've started operations, what if the couple of partners back away? They don't want to do it anymore. Well, they signed an agreement. A partner or creditor can bring a lawsuit to enforce a valid promise to make a contribution. That is an agreement, right? Contract law doesn't disappear just because we're talking about a new area of the law. A signed agreement by someone to pledge money, to give money once a business is up and running, is a contract to live up to that promise. Not doing so is breach of contract for which that party can be sued. Right? So capital contributions can be collected even if they have to be collected by going to the courts to do it. What about defective formation? Meaning you misfile or you improperly file a certificate. The problem here is that until a certificate is properly filed, you do not have the protection of a limited partnership. So if you're running your business, but you haven't properly set it up as a limited partnership, what's the downside of that? Limited partners do not have the protection of limited liability unless the business is properly set up. So, obviously a lot more formality, they may have a cause of action against the partnership for not doing so. So again, we're talking about complex issues as we get further and further into more sophisticated types of businesses. And that's the point here. In case of defects, limited partners may be liable as general partners. Can escape liability by filing certificate of amendment or certificate of withdrawal. I mean, they can do certain things, but how do they even know that it's a defective formation? So you can't guard against a risk unless you know of a risk. So again, we're talking about awareness, understanding that the protection of limited liability in a limited partnership is not automatic. Partnership agreements. We know that you don't need them in a general partnership. Do you need it in a limited partnership? Still no. Still a good idea, but still no. So a limited partnership agreement is a document that sets forth the rights and duties of general and limited partnership. It sets terms and conditions regarding operation, termination, dissolution, who needs approval, what. Again, you don't need it, but you should want to have it, particularly because you have two classes of owners. General and limited owners. What are they contributing? How much, will they get out in profits and losses? What are the rights and responsibilities of certain people? What about the right of survivorship for general partners? Do you want to address that? Absolutely a good idea to have always a partnership agreement, but definitely not required under state law. In order to even come up with an agreement, it requires approval of all the partners. So half the time you don't have an agreement because you can't reach agreement, because now you've got 5 general partners, 6 limited partners, and you're negotiating over the terms and conditions. You start to see that partnerships may not be the best form of business. They may be, they may not be. A lot of partnerships that we see are pretty small. The larger it becomes, the more unmanageable it might become. Shares of profits and losses. Here, limited partnerships differ from general partnerships. Why? Well, look, the default law is that profits and losses are shared on the basis of value. They're proportional. So here, it's a common sense. Whether you're a general partner or a limited partner, you get as much as you contributed. If you contributed 25%, you get 25% of profits and losses. But the agreement can trump that. It can specify exactly how you want to allocate. Because even if you contributed 25%, a general partner that contributed 25% as well is also running the business. Shouldn't they get more of the profits as a result of it? So you want to change it, you've got to put that into your partnership agreement that, again, has been agreed to by all the partners, right? So, there are a lot more intricacies, a lot more detail, a lot more formality, a lot more headaches that go along when you're running a business with, more than a couple of people or doing it individually. We talked about all these duties and rights that partners have. Even if you're a limited partner, you have a right to information. Each limited partner, whether they contribute a little bit or they contributed a lot, is an owner of that business, has a right to see the financial affairs of that business, has a right to keep, the partnership has a right to keep certificates, partnership agreements, income tax returns, financial statements, day-to-day operations, and to the extent that the limited partner wants to take a look at it, wants photocopies, and so on and so forth, they are entitled to this information. In a general partnership, you want to let in someone else. It's pretty clear. You got to get agreement of the other partners. What about in a limited partnership. You want to let in a new general partner. You want to let in a new limited partner. Well, the state law basically says that new limited partners can be added only upon the written consent of everybody. All partners, general and limited. That's cumbersome. That's not fair. Most limited partnerships will change that right away and say only general partners, not limited partners. We don't want to give them that kind of veto power. They may not be interested. We may not even be able to get a hold of them, or they just don't understand the business. I mean, we can let in as many, contributing limited partners as we want to. But again, not knowing what the default state law is doesn't help you if you want to change your partnership agreement. New general partner can only be admitted upon written consent of each partner. Agreement cannot vary this requirement. These are a lot of details that you don't necessarily need to have memorized, but understand that there is a lot more intricacy, a lot more governing terms and conditions that go along with partnerships. And in fact, there's far less with limited liability companies, which is why I'll keep saying most businesses are converting. They're not staying with archaic partnerships because partnerships are still pretty limited in terms of how they govern. And by the way, if you're letting in new people, you got to update your certificate of partnership. Otherwise, it's not current. If it's not current, you've got a problem. Limited partners are not being protected. And here again, it starts to get redundant. Look, if you're a general partner, you have unlimited liability. Whether you're in a general partnership or in a limited partnership, you're still a general partner, right? You cannot get rid of that problem of unlimited liability. However, if you are in a limited partnership as a limited partner, you're only liable up to your capital contribution, which means what? The money you invested into the business can be lost, but you're not personally responsible. And that's a big protection for limited partners. Creditors can enforce a personal guarantee and recover payment from a limited partner who guaranteed repayment of a loan. What does that mean? Well, that means what it says. I can be a limited partner, but I can be persuaded by the partnership, couldn't you please be a co-signer, a guarantor on this loan? You have so much money, we're going to get... And I say, sure, why not? I've just lost, for that, I'm a limited partner, but to the extent that the partnership defaults on that loan, as a guarantor, I'm still liable, right? I can't just say, oh, wait a minute, I'm a limited partner. But you personally guaranteed a loan, right? You've essentially become a guarantor, and you can't use the shield of limited partnership, right? So, these are common sense sort of things, but it's worth sort of just making that point. Remember we said that limited partners only get the benefit of limited liability if they don't participate in management? Well, that's true. General partners have management rights. Limited partners give up these rights. Why? Because they're getting limited liability. They're going to be liable as a general partner if they start behaving like one. If they start to take on day-to-day management, they're going to give up that protection. Only liable to persons who reasonably believe them to be general partners. Okay, that's sort of archaic, but what that means is if you start to act like a general partner, other parties, third parties perceive you as being a general partner, regardless of what the certificate says, you're going to lose protection of limited liability. You're going to get started treated like a general partner. That being said, there's still a lot of things that a limited partner can do. Can a limited partner be an employee of the business? Can they be a consultant? The answer is yes. That's not management, says the law. Okay. They can act as a surety, meaning they can sign a personal loan and so on and so forth. That's still okay. They can be a consultant. They can vote on partnership matters and so on. That kind of thing is still okay. I will tell you this, most limited partnerships don't want limited partners doing so much. But this is still permissible if the other partners agree to it. So, a simple slide that just sort of summarizes what we've all been just talking about. General rule is that limited partners are not individually liable for the obligations of the partnership beyond. If all I invested was $25,000 and the business gets sued for $1 million for negligence, I don't have to worry. I'm a limited partner. I would lose my contribution, the $25,000, but I am protected personally. But exceptions, limited partners are individually liable in 3 situations. When, number 1, defective formation, for the period of time that the paperwork wasn't properly filed. Number 2, if I take on too much of a role in management of the business, I will be treated as a general partner. Number 3, if I personally guarantee any debt, I will be personally liable there as well. Clear? Crystal clear? Let's hope. All right, we're at the end. How do you dissolve a limited partnership? The same way that you would dissolve any business. All right, I mean, to the extent that sometimes you just file a paperwork and you still continue the business. You can do that. But if the dissolution is actually the end of the business, then what we need to worry about is winding up the business. How do you wind up the business? Well, you pay off the creditors, you pay off the employees. Only then can money be paid off for the capital contributions and so on and so forth. There are other legal formalities that we won't worry about, but the order in which everyone is paid is almost always the same. Creditors come first, then come capital contributions, then come any profits or losses. So, I mean, that's typically true no matter what. But really, the quick point that I'll make, again, real quickly, is that just because a partner leaves and another one comes in, technically that is a dissolution. But once you sort of file continuing certificates, you're still continuing on the business, right? The winding up and the termination of a business is if the partners no longer want to carry it through, okay? Now, before LLCs came another sort of creature. GP, LP, ready for this one? LLLP, a limited liability, limited partnership. What? Okay, not very common. What is it? A limited liability, limited partnership is exactly what it says. It says we're going to have the type of business where both general partners and limited partners have limited liability. Everyone has limited liability. And this goes back to a point that you sort of make. Well, wait a minute. Everyone has limited liability. What's the trade-off? If no one is personally liable, a lot of states put conditions on that. A minimum running capital structure, a requirement that you carry minimum levels of business and malpractice insurance, and so on. And there are very few of these creatures because LLCs do the exact same thing. Why do you need a limited liability, limited partnership anymore? But remember, LLCs took time to catch on in every state. And some states said, well, in order to have an LLC, you need to have so many people and so on. These days, it doesn't carry a lot of weight, but these creatures still exist under state law, although they're not used as much because I wouldn't want a partnership at all. I would want, very simply, a LLC going forward. So we don't really care about this diagram. All this diagram really says is whether you're a general partner or a limited partner in an LLLP, you are only liable for your capital contribution. You get limited liability protection. But I'm just teaching it because for historical purposes, it was sort of evolutionary in that respect. I don't think anyone wants to stick around here any more than they have to.